A Supreme Court fight just turned your local gas station, coffee shop, and corner store into the center of the gun law battle in America. And if you carry, the next ruling could decide whether walking into a business with your lawfully carried handgun is normal conduct or a crime that can put you in jail for up to a year. Pause. Quick question before we continue. Are you subscribed? Because this is exactly the kind of update most gun owners hear about way too late, usually after the rule has already changed. If you want clear, simple breakdowns without the legal fog, hit that subscribe button right now. You do not want to find out about a carry law shift from a police officer during a bad traffic stop. Source. Here's what just happened. After the Supreme Court's 2022 Bruen decision said states cannot make ordinary people prove a special need just to carry in public, Hawaii rewrote its carry law. In 2023, it passed Act 52. That law did two big things. First, it created a long list of places the state called sensitive places. Second, and this is the part that shocked a lot of people, it flipped the normal rule for private property that is open to the public. In plain English, if you had a carry license, Hawaii said you could not bring your handgun into a business, restaurant, or other private place open to the public unless the owner clearly said yes. That yes could be a sign or direct permission. No clear yes meant no carry, and breaking that rule could be a misdemeanor. Pause. Now, this is where it gets interesting. Most people think this case is about all so-called sensitive places. It is not. The Supreme Court stepped in, but only on the private property question. That means the justices are not, at least in this case, deciding every fight about parks, beaches, banks, bars, buses, or all the other places states have tried to regulate after Bruen. They narrowed the issue. The question is much more specific. Can a state make it a crime for a licensed concealed carrier to enter private property open to the public unless the owner first gives express permission? That sounds narrow, but it is huge. Why? Because your daily life happens on private property open to the public. Grocery stores, pharmacies, gas pumps, restaurants, hardware stores. If the default rule is no carry unless the owner says yes, then your permit can start feeling useless in the real world. Source. Let me break this down for you with a real-world picture. Imagine you have a valid permit. You stop to get gas, then you grab coffee, then you run into a grocery store, then you pick up medicine. Under Hawaii's rule, unless those places clearly allowed carry, every one of those stops could become a legal risk. That is why challengers say the law does not just regulate carry, they say it quietly wipes it out in the places normal people actually go. But here's the crazy part. The Ninth Circuit allowed Hawaii's private property rule to stay in effect, even while other courts blocked similar rules in other states. That is one reason this case got so important so fast. When different courts treat similar laws differently, the Supreme Court often steps in. And that is exactly what happened here in Wolford v. Lopez. Pause. If you're finding this helpful, imagine what you'll learn in my next video about the exact mistakes gun owners make when they assume a permit works the same way in every state. Subscribe so you don't miss it. Because one bad assumption about where you can carry can turn a normal day into a criminal case. Source. So why does the title say the DOJ and states back this challenge? Because they do. The U.S. Department of Justice filed briefs supporting the gun owners, and that is a major deal. In its Supreme Court brief, the DOJ argued that Hawaii's rule is blatantly unconstitutional as applied to private property open to the public. The DOJ said states cannot dodge Bruen by giving people carry permits on paper, then criminalizing carry in the very places people use every day. The brief also argued there is no solid historical tradition for this kind of default no-carry rule on property open to the public, and the DOJ was not standing alone. A 27-state coalition, led by Montana and Idaho, also backed the challengers and argued Hawaii flipped the traditional rule on its head. Source. Now let me explain why that matters. When the DOJ backs one side in a Supreme Court case, people pay attention. When more than 24 states also back that same side, the justices know this is not some tiny local fight. This becomes a national conflict about how far states can go after Bruen. First thing, the challengers say the Second Amendment protects carrying for self-defense outside the home. Second, they say a state cannot turn almost every normal stop into forbidden ground. Third, they say history does not support this kind of rule. That history point matters because Bruen told courts to look at the text of the Second Amendment and the nation's historical tradition of firearm regulation. Then Rahimi, the court's 2024 decision, said courts should look for the principles behind historical gun laws, not just copy and paste old statutes. In other words, states still can regulate guns in real sensitive places like schools and government buildings, but they cannot just slap a new label on ordinary life and call it close enough. Pause. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Here's a hypothetical example to explain this. Say your state issues you a carry permit. You walk into a family diner with no metal detector, no armed guard, and no sign on the door. Most people would assume the question is simple. Either the state lets you carry there or it doesn't. But these newer laws create a hidden third option. The state says, maybe you can carry, but only if the owner clearly invited it. That sounds small. It is not small. That changes the default rule. And here is what most people get wrong. If the default rule changes, the burden shifts to you. You are the one guessing. You are the one risking arrest. You are the one who may have to explain later that there was no sign, no warning, and no bad intent. Source. Hey, 73% of people watching right now probably are not subscribed. Don't be part of that group. Join the people who get these legal updates before the headlines get twisted. Click subscribe now, because I break down what the court actually said, what it did not say, and what mistake could still get a lawful gun owner jammed up. Source. But wait, there's something even more important. We also got a preview of how the justices are thinking. At oral argument in January 2026, several of the court's conservative justices sounded skeptical of Hawaii's rule. Chief Justice Roberts suggested recent cases show the Second Amendment has been treated like a disfavored right. Justice Alito told Hawaii's lawyer the state was relegating the Second Amendment to second-class status. Justice Gorsuch pushed back hard on using an 1865 Louisiana Black Code as a historical example. Justice Kavanaugh basically asked why the court should make this more complicated than it needs to be if the history is not there. That is a strong signal. But do not make the mistake of thinking the case is over. It is not. Source. Here's the part nobody's talking about enough. The other side had arguments too, and some justices took them seriously. Justice Jackson focused on property rights. Her point was simple. Maybe this is not really a gun rights case as much as a rule about how property owners show consent. Justice Kagan suggested some historical laws might show states have changed default rules before. And Justice Barrett asked hard questions about private homes, basically testing where the challenger's theory stops. That matters because if the court rules for the challengers, it still may write a narrow opinion. The justices could say states cannot force a default no-carry rule on businesses open to the public, while still making clear that private homes, clearly posted businesses, and true sensitive places are different. So if you are hoping this case means carry everywhere, slow down. That is not what this case is about. And if you are worried this case means all no-gun signs disappear, slow down on that too. A private owner can still say no. The real fight is over who gets the benefit of the doubt before the owner says anything at all. Source. And here is why this could reach far beyond Hawaii. Similar default rules showed up after Bruen in places like California, New York, New Jersey, and Maryland. So even though Wolford is a Hawaii case, the logic of the decision could hit multiple states. If the challengers win, courts around the country will likely use that ruling to strike down similar ask first or go to jail rules. If Hawaii wins, states may feel encouraged to keep using private property defaults as a workaround, even when broad, sensitive place bans get challenged separately. That is why I said this could end one of the most unclear carry rules in America. Not because the court is about to answer every gun question. It is not. But because it may finally answer this one very dangerous question. When your permit says you can carry, does that right mean anything in the everyday places you actually go? Pause. This is the kind of information that changes fast the moment a Supreme Court opinion drops. Subscribe now, because my next video will explain exactly what a Wolford ruling would change, what it would not change, and the first 3 places gun owners should recheck in their own state the same day that opinion comes out. Source. So here's the bottom line. As of right now, the Supreme Court has not issued its final decision in Wolford v. Lopez, but the court agreed to hear the case, the DOJ backed the challengers, 27 states backed them too, and the oral argument suggested several justices are deeply uneasy with these unclear default no-carry rules. That means a major clarification could be coming later this term. Pause. Until that opinion is out, do not guess. Do not assume your permit works the same way across state lines. Do not assume a silence on the door means safety for you in court. Stay alert, stay informed, and if you want the fastest plain English breakdown when this ruling lands, subscribe right now and turn notifications on. I make these videos for one reason. So good people do not get trapped by bad rules and confusing laws. And one last thing, this video is for education only, not legal advice. Gun laws are different from state to state, and the safest move is always to check your local law and talk to a qualified attorney before you act.